That junk truck gets towed tomorrow morning, and you owe us $14,000 in fines." Derek Slade said it loud enough for 3 neighbors to hear. That was the point. He was standing at the edge of Roy Ellison's gravel driveway, arms crossed, wearing a pressed polo shirt with the Cedar Brook Estates logo stitched over the left breast. 43 degrees outside. He hadn't bothered with a jacket. The rules are the rules, Mr. Ellison. Nobody is above the community standards here. Roy was 72 years old. His hands were black with grease from a carburetor he'd been rebuilding since 7 that morning. He didn't raise his voice. He didn't step forward. He just wiped his hands on a shop rag, looked Derek Slade directly in the eye, and said, "You might want to take a look at where you're standing before you start telling people to leave." Derek blinked, then laughed, the kind of laugh that meant he wasn't actually listening. 3 days later, the entire Cedar Brook Estates HOA board stood before a judge in Carver County Circuit Court. Every one of them pale-faced, every one of them quiet, because Roy Ellison had known a secret for 60 years. The kind of secret that doesn't expire. The kind that gets more valuable the longer someone tries to push you around. This is that story. Roy's father, Walt Ellison, bought the land in the spring of 1947. 4 acres in Carver County, Indiana. Flat ground, good drainage, close enough to County Road 14 to get a truck in and out without trouble. Walt paid $200 for it, cash, from a coffee can he'd been filling since before the war. No bank involved, no mortgage, no monthly payment to anyone. Walt built a 2-room house that first summer, poured the foundation himself, cut the lumber himself. His neighbor, a man named Peterson who ran cattle 2 miles east, helped him raise the walls over a single weekend. Peterson brought his sons. Walt cooked a ham. By 1952, the house had 4 rooms. By 1958, it had a workshop out back. That same year, 1958, Carver County sent a surveyor out to remap the area. New plat maps, clean legal descriptions. The surveyor walked every inch of Walt Ellison's property with a transit and a chain. Drove iron pins into each corner, wrote everything down in a ledger that went into the county recorder's office on Main Street in Millhaven. Walt kept a copy, folded it twice, slipped it into a manila envelope, and put it in a metal lockbox under the workbench. "Keep your paperwork," he told Roy. "The land doesn't lie. The paper proves it." Walt Ellison died in 1987. Roy inherited the land, the house, the workshop, and the lockbox. He never moved, never saw a reason to. For 30 years after Walt died, the land around Roy sat quiet. Cornfields to the north, a fallow pasture to the east, a tree line to the west that turned orange every October like clockwork. Roy worked the workshop, took on small engine repair jobs for farmers in the county, kept a garden in the back. He drove the same 1987 Ford F-250 his father had bought the year he died. The truck had rust along the wheel wells and a crack in the passenger side mirror that Roy had fixed with electrical tape sometime around 2003. It ran fine. That was enough. Then, in 2007, the cornfield to the north got sold. Roy watched from his porch as the survey crew came in. Orange flags, string lines. A man in a hard hat walking the field with a clipboard. Roy didn't go over and introduce himself. He just watched. By 2009, Westfield Development LLC had broken ground on what they were calling Cedar Brook Estates. 47 homes, paved streets, a small pond with a fountain in the middle that ran on a timer, street lamps that looked like they belonged in a catalog, a brick entrance sign with the community name in brushed bronze letters. They built around Roy's 4 acres the way water moves around a rock. His property sat dead center inside the new development, surrounded on all 4 sides. The new paved road that Westfield cut through the old cornfield, the only road in or out of Cedar Brook Estates, ran along the northern edge of Roy's land. Right along it, close enough that you could stand on Roy's gravel and touch the asphalt with the toe of your boot. Westfield sent Roy a letter in 2009, friendly tone, offering to buy him out. A number that sounded large until you understood what 47 homes surrounding your property would do to the land value. Roy read the letter at the kitchen table, folded it back along its original crease, set it on the stack of mail by the window. Never responded. Westfield sent 2 more letters that year. Then they stopped. The development filled up. Families moved in. Kids rode bikes on those new paved streets. The fountain ran every morning from 8 to 6. Life went on. And Roy kept fixing small engines in his workshop and driving his rusted F-250 to the hardware store in Millhaven on Saturday mornings. For 12 years, nobody bothered him. Then Derek Slade got elected HOA president. Derek was 34 years old. He'd moved into Cedar Brook Estates 18 months earlier with his wife and their 2 Labrador retrievers. He worked in commercial real estate in Indianapolis, drove 40 minutes each way, 5 days a week. He had an MBA from a state university, a lease on a black Audi, and the specific kind of confidence that comes from never having been seriously wrong about anything yet. He ran for HOA president on a platform of raising community standards and protecting property values. 17 people voted. Derek won by 4. The first thing he did was commission a new community map, a clean, color-coded diagram of every lot in Cedar Brook Estates. He had it laminated and hung it on the wall of the HOA meeting room, which was really just the finished basement of a house on Birchwood Lane that the previous board had designated as the official meeting space. Derek stood in front of that map the night of his first official meeting and pointed to the center of it. There was a white space there, unlabeled, 4 acres, sitting in the middle of everything like a missing tooth. "What is that?" he asked. The previous board president, a retired schoolteacher named Carol, who had held the position for 6 years without incident, explained that it was private land. Pre-existing, the original owner had declined to join the HOA. The development had been built around it. "So he's not a member," Derek said. "Correct," Carol said. "Then he's not subject to our rules." Carol looked at him carefully. "That's right." Derek nodded slowly, still looking at the white space on the map. That should have been the end of it. It wasn't. 6 weeks later, Roy found the first notice in his mailbox. White envelope. Cedar Brook Estates HOA letterhead. Formal language about community aesthetic standards. It referenced a section of the HOA bylaws, Section 4, subsection C, regarding the storage of inoperable or unsightly vehicles on residential property visible from common areas. The violation, his 1987 Ford F-250. The fine, $200. Roy read it standing at the mailbox, folded it once, walked back inside and put it in the kitchen drawer where he kept batteries and rubber bands and things he hadn't decided what to do with yet. The second notice came 3 weeks after that. Same letterhead, same bylaw citation, new language about non-compliance. The fine had increased to $350 per day, retroactive to the date of the first notice. Roy did the math on the back of an envelope. Said nothing to anyone. The third notice came certified mail. It had the name of a law firm in the return address. Thorne and Caulfield Legal Group, Indianapolis. The language was no longer friendly. It cited accumulated fines of $8 out of $400, demanded immediate removal of the vehicle, and referenced the HOA's authority to pursue legal action and property liens. Property lines. Roy set that letter on the kitchen table and looked at it for a long time. Then he picked up the phone. Not to call a lawyer, not yet. He called his neighbor, a man named Gerald Pitts, who farmed the remaining acreage east of the development and had known Roy for 40 years. "Gerald," Roy said, "you still got that contact over at the county recorder's office?" "Patty?" "Sure. Why?" "I need to pull some old survey records." "Nothing urgent." Gerald said he'd make a call. Roy hung up, walked out to the workshop, went to the workbench, crouched down, and pulled the old metal lockbox from the shelf underneath. The hinges creaked. Inside, under a 1974 property tax receipt and a folded copy of Walt's original warranty deed, was a manila envelope. He opened it slowly. The survey plat from 1958 was still there, faded along the folds, crisp everywhere else. Roy spread it flat on the workbench under the shop light. He looked at it for a long time, not like a man searching for something, like a man confirming what he already knew. Outside, the Cedar Brook Estates fountain ran on its timer. The sound of it carried faintly through the workshop wall. Roy folded the map back along its original lines and slid it into the envelope. 2 weeks after Roy pulled that lockbox from under the workbench, he drove his F-250 into Millhaven, not to the hardware store. He parked on Clement Street, outside a narrow brick building wedged between an insurance agency and a closed-down diner. A small sign above the door read, "Pruitt Land and Title Law." The paint on the sign was faded, but the lettering was still clean. Roy walked in carrying a manila envelope and a brown paper bag with 2 coffees from the gas station down the block. Sandra Pruitt was 51 years old. She'd spent 11 years at the Indiana State Office of Land Registration before opening her own practice in Millhaven. Her office had 3 filing cabinets, 2 chairs, a desk buried under title abstracts, and a wall map of Carver County that was more annotated than the county's own official version. She took the coffee without asking what it was. People who came to her office with gas station coffee and manila envelopes were never there for a simple question. Roy laid 3 things on her desk: the 1947 warranty deed, Walt Ellison's name on the top line, the legal description of 4 acres in Carver County, meets and bounds, written in the formal language of a different era, the 1958 survey plat, crisp fold lines, iron pin locations marked in red ink by the original surveyor, every boundary line measured to the inch, and a stack of HOA violation notices, 8 of them now. The total fines listed on the most recent letter, $14,000. Sandra didn't touch the notices. She went straight for the 1958 plat. She spread it flat, pulled a magnifying glass from her desk drawer, leaned in close to the lower left corner where the surveyor's notes ran in small, precise handwriting along the margin. The room was quiet. Roy drank his coffee. Sandra read. Then she stopped. Pulled the map closer. Read the same section again. She set the magnifying glass down. Looked up at Roy. How long have you known about this? Roy set his coffee cup on the edge of her desk. Since the day they poured the asphalt. Sandra leaned back in her chair slowly. Outside on Clement Street, a truck rumbled past. The window glass trembled faintly. Mr. Ellison, she said. Do you understand what this means? I've got a general idea, Roy said. That's why I'm here. I want to make sure I'm right. Sandra turned the plat map around and pointed to a thin line running along the northern boundary of Roy's property. A dashed line, annotated in the margin with 7 words in the surveyor's handwriting. Private easement. Non-transferable. Consent of owner required. 12 feet wide, running the full length of Roy's northern boundary. The exact path that Westfield Development LLC had paved over in 2009 to create the only road in and out of Cedar Brook Estates. That road, the road that 340 residents used every single day to leave for work, to pick up their kids from school, to bring home groceries, ran across land that had never stopped belonging to Roy Ellison. Westfield hadn't caught it in their title search. Either they'd been careless or they'd assumed the easement was transferable. It wasn't. The annotation said so in plain English. Written by a county surveyor in 1958. Witnessed. Recorded. Filed at the Carver County Recorder's Office, where it had been sitting in a cabinet on the 3rd floor of the courthouse building on Main Street for 66 years. Available to anyone who thought to look. Nobody had looked. They built an entire gated community, Sandra said quietly, on the assumption that road was theirs. They built it on the assumption I didn't know, Roy said. Sandra was quiet for a moment. Every fine notice they sent you, she said. Every certified letter. Every time Derek Slade drove through that entrance to come knock on your door. He used my road to do it, Roy said. Every single time. Sandra looked at the stack of violation notices again, then at the plat map, then at Roy. She picked up her pen. We're going to need to file a response, she said. And a counterclaim. I figured, Roy said. The counterclaim is going to be larger than $14,000. Roy nodded once, finished his coffee, set the empty cup down. I'm not in a hurry, he said. Get it right. If this story is the first time you've heard about easement rights and what they mean for property owners, you're not alone. Most people don't find out until it's too late. Hit subscribe and turn on notifications. The next story involves a water rights dispute in Texas that makes this one look straightforward. Sandra spent 3 weeks building the file. She pulled the original Westfield Development plat from 2008, the one filed with Carver County before construction began. She cross-referenced it against the 1958 survey. The discrepancy was not subtle. The easement annotation was visible on the original county plat records. It had simply been overlooked or ignored. She contacted Thorne & Caulfield Legal Group and informed them that Roy Ellison would not be paying any fines, that the HOA had no jurisdiction over his property, and that a formal counterclaim was being prepared. Marcus Thorne called her back the same afternoon. He was confident on the phone, the kind of confident that comes from billing $400 an hour and winning most of your cases on intimidation alone. Your client is not in compliance with community standards, Thorne said. The vehicle is clearly visible from common areas. The bylaw is straightforward. Mr. Thorne, Sandra said. Your client's common area road runs across my client's private property. I'd suggest you pull the 1958 Carver County Survey plat before our next conversation. Silence. Not long. 3 seconds, maybe 4. But Sandra counted them. I'll review the file, Thorne said. His voice had dropped half a register. Take your time, Sandra said. We'll see you in court. The hearing was set for a Thursday morning in February. Carver County Circuit Court, Room 4, 8:30 a.m. Derek Slade arrived with Marcus Thorne and 2 members of the HOA board. Derek was wearing a charcoal suit, new haircut. He carried a leather portfolio with the HOA's violation documentation, photographs of Roy's truck, time-stamped, organized by date, 47 pages. He looked like a man who had already won. Roy arrived 7 minutes later. He wore the same canvas work jacket he'd owned since 1999, clean but worn at the elbows. He carried nothing except the manila envelope. He sat down, placed the envelope flat on the table, and folded his hands on top of it. Derek glanced over once, looked away. The judge, a woman named Patricia Wells, who had been on the Carver County bench for 19 years, called the room to order and asked each side to present their opening position. Marcus Thorne went first. Organized, professional. He laid out the violation history, the bylaw citations, the accumulated fines. He referenced property values, community standards, the HOA's legal authority under Indiana State Code. He spoke for 11 minutes. Judge Wells listened without expression. Then she looked at Sandra Pruitt. Sandra stood up, walked to the bench, placed 2 documents in front of the judge, the 1947 warranty deed and the 1958 survey plat. She spoke for 4 minutes. When she sat down, the courtroom was quiet. Judge Wells studied the plat map. She put on her reading glasses. She looked at the margin notation, those 7 words in the surveyor's handwriting. She looked at it for a long time. Marcus Thorne opened his leather portfolio, turned a page, turned it back. His pen was in his hand, but he wasn't writing anything. Derek Slade's expression was the same face a man makes when he reaches for his wallet and finds the pocket empty. A brief stillness, then a very controlled attempt to look like nothing had happened. Judge Wells took off her reading glasses. Mr. Thorne, she said, was a title search conducted on the adjacent parcels prior to Westfield Development's construction filing in 2008. Thorne stood. Your Honor, Westfield Development is not a party to this. The road is, the judge said. Was a title search conducted? A pause. I would need to review the construction records, Your Honor. You have until tomorrow morning, Judge Wells said. 9 a.m. She set the plat map down on her desk and looked at both tables. We'll recess until then. Thorne and Caulfield called Sandra at 6:15 that evening. They were prepared to settle. The settlement offer came in writing the next morning. Thorne and Caulfield proposed dropping all fines, a formal written apology from the HOA board, a one-time payment of $18,000 to cover Roy's legal fees and damages. Sandra read it at her desk. Then she called Roy. They want to settle, she said. I heard, Roy said. What do you think? I think they're scared, Sandra said. And I think they should be. The easement issue doesn't go away with a settlement. We still need a formal legal ruling on road access. Otherwise, they'll find another way to push back in 2 years. Roy was quiet for a moment. Then we go back in the morning, he said. Court resumed at 9 a.m. Sharp. Thorne arrived without Derek Slade. One of the HOA board members sat in the back row. The other hadn't come at all. Judge Wells reviewed the construction records Thorne had submitted overnight. A title search had been conducted in 2008 by Westfield Development. The easement annotation on the 1958 plat had been noted in the raw survey data. It had not been carried forward into the final title report. An oversight. 66 years old, worth considerably more than $14,000. Judge Wells ruled in 40 minutes. All HOA fines against Roy Ellison dismissed. The Cedarbrook Estates HOA had no jurisdiction over his property. His land had never been part of the development, had never been subject to their bylaws. The violation notices, every one of them, were legally void from the date of issue. On the counterclaim, the HOA, as the operating body responsible for maintaining Cedarbrook's common road, had been using a private, non-transferable easement without the owner's consent for 12 years. That constituted ongoing trespass under Indiana property law. The court ordered the following: Cedarbrook Estates HOA to pay Roy Ellison $31,000, covering legal fees, damages, and back compensation for 12 years of unauthorized road use. And going forward, a formal easement lease agreement to be signed within 30 days, granting Cedarbrook Estates continued use of the road across Roy's northern boundary at a rate of $874 per month, adjusted annually for inflation, terminable by the property owner with 90 days written notice. Marcus Thorne wrote something in his portfolio, then stopped writing, sat very still. Judge Wells signed the order, closed the file. We're adjourned. Derek Slade resigned from the HOA board 11 days later. The resignation letter cited personal and professional obligations requiring his full attention. He and his wife listed their Cedarbrook home for sale 6 weeks after that. They moved to a newer development outside Indianapolis by late spring. Roy heard about it from Gerald Pitts, who had heard it from someone at the Millhaven hardware store. Roy nodded. Went back to the carburetor he was rebuilding. The $31,000 check cleared on a Tuesday. Roy deposited it at the Millhaven branch bank, drove home, bought a new hydraulic lift for the workshop with part of it, put the rest in the account he'd been adding to since 1991. The $874 monthly payments started arriving by the first of each month like clockwork. Direct deposit. Roy barely looked at them. The F-250 still sat in the driveway. Same spot, same rust along the wheel wells, same electrical tape on the passenger mirror. Nobody filed a complaint about it. Nobody sent a letter. Nobody came to the door. There's a particular kind of man who built this country and then got quietly surrounded by people who forgot he existed. Men who kept their paperwork, who didn't make noise, who understood that the land remembers even when the people don't. Roy Ellison didn't win because he got lucky. He didn't win because he hired the most aggressive lawyer in the county. He won because his father told him to keep his paperwork in 1958, and he listened, and he never threw anything away. Derek Slade had an MBA and a laminated map and 47 photographs of a truck. Roy had a manila envelope and 66 years of patience. The truck stayed. The man stayed. The road they'd paved over his land. The road they'd used to come threaten him. The road that 340 families drove every single morning without knowing whose ground was underneath. Kept paying him every first of the month. Some men fight loud. Some men just wait for the paper to speak. If you've made it this far, you already know someone like Roy. Maybe you are Roy, the man who doesn't argue, doesn't explain himself, just keeps his documents clean and his words solid. Subscribe if that story means something to you. There's more where this came from.